Good morning, friends. As if the Income Tax Act, FCRA, labor laws and other state acts were not enough to bother and burden the charitable organizations with their restrictions and regulations, here comes the Prevention of Money Laundering Act. Recently, the Finance Ministry has amended the anti-money laundering rules to incorporate more disclosures for non-governmental organizations by reporting entities like financial institutions, banking companies or intermediaries. The rules were notified by the Gazette notification released by the ministry. Do you know what's there in store for you? Watch this video till the last minute so that you don't miss upon any important information which otherwise could land you in serious trouble. I am Ashis Agarwal from Team NGOenabler, and today in this video I shall cover few key amendments made in the Prevention of Money Laundering Act which are relevant in the context of NGOs. The new rules have laid down the procedure for how this information will be shared, the time for which such data will be released, the manner in which the identity records of the NPO clients will be maintained on the nature and value of transactions. To start with, the definition of NPOs. I repeat, the definition of NPOs itself have been amended under the Act. I would rather say it has been made more specific to include the charitable and religious organizations in line with that defined in the Income Tax Act. Earlier, the definition of the NPO was any entity or organization that is registered as a trust or a society under the Societies Registration Act or any similar state legislation or a company registered under the Companies Act. After the amendment, the definition of NPO looks something like this. Any entity or organization constituted for religious and charitable purposes under the Income Tax Act. I repeat, any entity or organization constituted for religious or charitable purposes as per the definition laid down in section 2 subsection 15 of the Income Tax Act, that is registered as a trust or society under the Societies Registration Act or any similar state legislation, or a company registered under the Companies Act. The next amendment is via insertion of new sub-rule which states that in case of NPO clients, every banking company, financial institutions or intermediaries have to register them on the Darpan portal of Niti Aayog if not registered. They now also need to maintain such registration records of their NPO clients for a period of 5 years from the end of the relationship or the closure of accounts, whichever is later. So let's see what exactly the notification has to say regarding this point. As per the notification, every banking company or financial institution or intermediary, as the case may be, shall register the details of a client in case of client being a non-profit organization on the Darpan portal of Niti Aayog if not already registered, and maintain such registration records for a period of 5 years after the business relationship between a client and a reporting entity has ended or the account has been closed, whichever is later. Doesn't this indirectly implies that all non-profit organizations now need to register themselves on the Darpan portal of Niti Aayog, which otherwise was mandatory only for FCRA registered organizations till now? Yes, of course, this means exactly what you have understood, because all the NPOs must surely be operating one or more bank accounts with one or the other banks. Another purpose with which it has been done is to have some repository of basic information on all the NGOs in the Darpan portal of Niti Aayog. So beware now, someone is always keeping an eye on you. Also, you need to give a thought that the banks shall keep the 5 years record with them, but what about you? If you are subjected to intense scrutiny under this act, are you ready to face the investigation? Are you updated with all the records and have synchronized it well? 100% Most of you must not have done so. Here comes the importance of digitizing your records, which we have been emphasizing from past several years. Watch our video on the topic Importance of Digitization for NGOs by clicking on the I button on the screen. Another major amendment which has been brought in is related to submission of the due diligence documents. Until now, the documentation was limited to obtaining the basic KYCs of the clients, such as the registration documents, PAN copies, and the documents of officers holding an attorney to transact on behalf of the clients. The scope of such documents have now been broadened to bring into its ambit the submission of details such as the name of the persons including senior management positions, names of the directors, name of the beneficiaries, trustees, settlers, or the authors as the case may be, depending upon the legal form of the organization. Also, the details of the registered office address and the principal place of activities. I repeat, the details of the registered office address and the principal place where the organization is carrying out its activities are now required to be submitted by the NPO clients to financial institutions, banking companies, or the intermediaries. In our opinion, keeping an eye on each transaction being carried out will surely bring in more transparency and accountability in the functioning of the NPOs and ensure propriety in the use of funds only towards the objects of the organization. So friends, please take these amendments seriously because it might seem to have come for the reporting entities like banks, financial institutions, or intermediaries, but can have serious implications on the NPOs if not adhered to. For more such updates and tutorials, keep tuned to our channel, and for any clarifications, feel free to comment or contact us. Thank you.